Welcome everybody here. I am Chris Anderson. I am the president-elect of the Greater San Diego Association of Realtors. And before turning things over to our guest, I want to provide some brief background on this issue. The county board of supervisors, they have a rent control and eviction moratorium that was approved on May 4th, despite overwhelming opposition from our realtors, property owners, and allies at the apartment association. I want to thank the about 600 of the members of our members and homeowners who emailed their supervisors to express the opposition, and also more than 700 e-comments that were posted almost entirely in opposition. We oppose this for many reasons, not the least of which it runs in clear opposition to private property rights, but also that it will restrict our ability to provide safe, affordable housing options in our region. So while this is written as a temporary ordinance, we know that the intent for some is to extend or make it permanent with many of the provisions that they had in there. So our fight is far from over, and we are now supporting a legal challenge on this ordinance. So if you know of anybody who is directly affected by this or impacted by this ordinance, we would love to have you reach out to us. You can email Ryan Maxon with their information, and we are specifically looking for people who would be interested in signing in on a lawsuit against this ordinance. So Ryan's email, if you don't have it, is rmaxson, M-A-X-S-O-N, at sdar.com. Again, that's rmaxson and at sdar.com. And his information will be included in the follow-up to this. We'll send out an email. Thank you guys for attending today. So with all that, I would love to introduce a very good friend and an expert real estate attorney to give an overview of the ordinance and how it's going to impact real estate, the professionals, and the homeowners, all of us alike. So Shanna Welsh Levin is a partner and corporate lawyer with SoCal Realty Law, which she opened in September of 2011. That's crazy, Shanna. Can't believe it's been
a long time.
It's
been a while.
And, yes, and a member of the State Bar of California and the San Diego County Bar Association. She is a member of the Real Property Law Section Executive Committee and was elected chair of the Real Property Law Section during 2015. She is also a licensed broker and active member at SDAR. Thank you. And she has also helped craft California's short sale and anti-deficiency statute known as Senate Bill 931. Any of you guys that have been in this profession for quite some time and you had to go through that lovely episode of all the short sales, Shanna really made it so that we could help out our clients, the homeowners, so they could get back into the market and buying again. So thank you, Shanna, for that. She worked with Senator Denise how do you say her last name? Yeah, Duchesne, that's it.
No longer in office.
The bill. Yeah, to work on the bill, and it went into effect on January of 2011. The bill aimed to protect consumers from their lenders when they were unable to pay off their balance on their home, on their mortgage. And the bill made it mandatory for lenders to forgive the remaining balance of the mortgage debt, called the deficiency balance, when the homeowner or borrower completed the short sale of their home. So it really helped out a lot of our clients and also helped out for them in the future to buy again quickly. Ms. Welsh holds the degree of Juris Doctor from California Western School of Law in San Diego, California, and she graduated magna cum laude from the University of Pittsburgh. What an accomplishment. Thank you, Shanna, and thank you for being here today. We really look forward to hearing what you have to say.
Thank you so much, Chris. I really appreciate being asked to be here. It's quite an honor to be asked by SDAR to present on this topic. And, you know, you got the long version of the bio. I appreciate that. I am always interested in kind of being on ground zero. You know, I've been to many CAR legislative days and appreciate being a part of all of this, because I do think that the Association of Realtors is one of the most powerful groups, professional groups, to help us overcome these challenges or deal with these challenges or whatever the plan is. So if it's okay, I will share my screen and get my PowerPoint going.
That'd be
And by
great.
the way, Chris, I've known Chris forever. She is amazing. I am so excited to see you as the president-elect. And
Thank you.
yeah, and also Carla is a good friend, and we've known each other for a long time as well. I've been on the Housing Opportunities Committee, Government Affairs Committee at SDAR, and so I have a lot of friends, I think.
Yes,
And
a lot of great input on all those committees. If you guys haven't thought about being on a committee, those are great committees to be on. They really help our clients and for our region.
Yeah, it really helps to understand what the association does. And so this is me. I've been a real estate attorney since 2004, 2005, everything was great. And then 2007, 2008, I kind of rode that whole wave out, and that's what made me interested in legislation and being a part of whatever is happening in real estate law. I'm also the president of Amicus, and we are seeking to house women and children in San Diego County by introducing emergency sleeping cabins. And that's a project that's going forward in El Cajon. So you can ask me about that later. At SoCal Realty Law, we protect real estate investors and real estate professionals. So today we'll talk about navigating the County of San Diego Eviction Moratorium. And in context of navigating what just happened, what was just issued in an ordinance by the San Diego Board of Supervisors, I have to put it in context by giving you a full update on the California Eviction Moratorium, because unless you understand what was happening, it's hard to understand what has just happened. So today we'll talk about the COVID-19 Tenant Protection Act of 2020. I'll talk about that as the COVID Act or the 2020 Act. And I was calling that one our roadmap through the end of the California Eviction Moratorium, because there was a deadline on that one, subject to potential extensions. And then we will also talk about the federal eviction moratorium a little bit, which was the moratorium defined by the Centers for Disease Control. Those CDC regulations created another federal eviction moratorium. And then there have been changes and extensions to all of these regulations. There's also the San Diego commercial eviction moratorium that's only for the city of San Diego. There are very few commercial eviction moratoria. I'll discuss some federal funds that are available to help landlords. And then we will cover in depth the new San Diego County Board of Supervisors eviction moratorium that was voted on last week. So on May 4th, the Board of Supervisors had this meeting, had a vote. There were many, many hours of comments, as Chris was saying, and that set a 30-day deadline for the ordinance that they passed to go into effect. So as of June 3rd, that ordinance will go into effect. But primarily the laws that we'll talk about today relate primarily to residential properties and not so much commercial properties. So in January, California lawmakers announced an extension of the California Eviction Moratorium, specifically those restrictions imposed by the COVID-19 Tenant Protection Act of 2020, which came into effect way back in late August, early September 2020. That act created certain restrictions against evicting residential tenants for non-payment of rent and evicting tenants without cause. They were scheduled, those regulations were originally scheduled to expire on January 31st. So we had a lot of clients and people waiting for February 1st to move forward on non-payment of rent evictions. But then that was extended, and those restrictions, when they were extended, it extended them through June 30th, 2021. So now the deadline became July 1st, or it was July 1st, to see if we could start moving forward with non-payment of rent evictions and other kinds of restricted evictions. Last week, what happened with the Board of Supervisors really changed the picture and the schedule that we were on. So the County Board of Supervisors new ordinance is only for the county of San Diego. The California eviction moratorium is for the whole state of California. So we now have a unique law just in our county that as of June 3rd, 2021 is going to really restrict almost every kind of eviction. And the new ordinance requires, in particular, just cause defined as quote unquote an imminent health or safety threat. Specifically, the tenant has to be a hazard to the health or safety of other tenants or occupants of the same property. So if you're talking about a single family residence and there's just one family there, or maybe even just one tenant there, it's impossible to evict them under the Board of Supervisors ordinance. Also, the ordinance, if the property itself is a health and safety hazard, if the property itself is uninhabitable, that is not a reason to evict under the new ordinance. So if the landlord were to violate the new San Diego County ordinance and then go to court and have a judgment issued against the landlord, the ordinance identifies the tenant as a prevailing party in any eviction lawsuit. That identity as a prevailing party subjects the landlord to liability for the tenant's costs, attorney's fees, if the lease agreement provides for attorney's fees, and an affirmative action by the tenant for an injunction to stop the eviction, as well as possibly treble damages, 3 times the tenant's actual damages for any quote unquote knowing or reckless violation. So this implies punitive damages. Well, it doesn't imply, it actually states punitive damages are available to tenants against landlords who violate the ordinance. But it also implies the danger of retaliatory eviction claims and wrongful eviction claims by tenants if for some reason they get through the court process and win. So then California, as we know, already had a very, very serious housing crisis. And that resulted in our 2019 Tenant Protection Act, which we reference as AB 1482, or the Rent Cap and Just Cause Eviction Statute. That 2019 Act was a major step toward requiring just cause for more evictions. So that was a move by the state in the direction of requiring landlords to do evictions based on just cause, as opposed to being able to give a notice, a 30-day or a 60-day notice for no cause. And after the 2019 Act, there were still many properties that were not subject to the 2019 restrictions, where, you know, in parts of the county other than the city of San Diego, landlords were able to do some evictions without just cause. But now, since the 2020 COVID Tenant Protection Act, as well as the Board of Supervisors new ordinance, every residential eviction in San Diego County and throughout California now requires just cause. I will come back to the definition of just cause, and we've got some great slides that will help you understand what that means. First, we'll talk about whether a landlord can increase the rent. This is a very common question. As of right now, in the way that these laws were written, even though you can't evict someone for non-payment of rent, the new statutes, both the 2020 COVID Act and the San Diego Board of Supervisors Act, still provide that the tenant has the obligation to pay rent. It doesn't relieve them of that obligation. So under current law, after August 1st, under the state statutes, landlords will be able to obtain judgments against tenants for non-payment of COVID-related rental debt. Even if that amount exceeds $10,000, landlords will be able to go to small claims court and obtain a judgment that exceeds $10,000, because there's a special exception for COVID-related rental debt. That kind of debt is rental debt that was owed anytime from March 2020 through the end of COVID. But I have in red and in bold on this slide that we're cautioning anyone against rent increases. The reason that we're cautioning against the rent increase is because the February legislation, which was AB 80, it extended the 2020 COVID Act, and it added some restrictions against charging late fees and penalties to someone who owes COVID-19 rental debt. It creates a very high danger of retaliation claims by a tenant. It creates some penalties against landlords who violate the COVID Act by retaliating against tenants. And so when you interpret the terms that are used, you say, okay, you're restricted as a landlord from charging late fees or any penalties. A rent increase could be interpreted as a penalty. A rent increase could be interpreted as retaliation against the tenant for doing a lot of different things, maybe raising some issue about the condition of the premises. And if a landlord were to find themselves in a position where they're defending against the tenant who's claiming retaliation, that rent increase could look very bad and work against the landlord. But on the landlord side, the new AB 80 added some relief from liability for the landlord who temporarily has to reduce or make unavailable a service or an amenity as a result of compliance with federal, state, or local public health orders and guidelines. So there was a bit of a balance that the state tried to reach with the AB 80 this year by adding a little bit of relief for a landlord from some of that liability. But all of the new laws strongly warn against any kind of retaliatory eviction for non-payment of COVID rental debt. And the new ordinance not only provides the implication of a very, the implication or a presumption of retaliation, but also punitive damages and other statutory penalties, and identifying the tenant as a prevailing party in any lawsuit that they win under the ordinance. Now, with regard to increasing rent, if a landlord were to take the risk against my advice to increase the rent during COVID, the San Diego County Board of Supervisors limits the rent increases to CPI of the previous year. This restriction only applies to properties that are not exempt from the Tenant Protection Act of 2019. So a property that is not exempt from AB 1482, rent cap and just cause eviction, is also subject to the San Diego County Board of Supervisors rent cap. What is CPI of the previous year? Let me see if I can share this. I have a letter from the State Board of Equalization dated December 31st, 2020. And it says down here, they calculate the CCPI, California CPI, increase from these numbers, rounded to the nearest 1,000th of 1%. This is an increase of 1.036%. And then there's an instruction here to accordingly, please prepare your 2021 assessment roll using the inflation factor of 1.01036. So I am using this 1.036% as my CPI number. I could be wrong. It's a little bit unclear because CPI wasn't very well defined by the state, by the County Board of Supervisors. But it indicates that rent increases as of June 3rd and until this ordinance is lifted, you could only potentially increase the rent 1.036%. Now the AB 1482 for properties that are exempt from AB 1482, I'm sorry, let me see this. The AB 1482 rent cap for properties that are not exempt is 5% plus CPI. So my calculation of that amount is 6.036%, 5% plus 1.036%. Properties that are not exempt, I'm saying this wrong, properties that are exempt from the rent cap and just cause eviction statute would still follow the 10% limitation on increases within a 30-day period. But as I said, we really are discouraging any increases in rent. How can a landlord collect the rent? As I mentioned before, there is a very generous lift on the cap in small claims court for landlords to pursue judgments for rent after August 1st, 2021, depending on whether that gets continued. There's already, like by continued, I mean extended. There's already pending legislation proposing to extend the time period on that into 2022. Okay, federal eviction moratorium, just briefly, this is the rules that were issued by the Center for Disease Control, which proposed to halt evictions. It was passed initially and was set to expire in January, and then it was extended through March 31st, 2021, and extended again through June 30th, 2021. So currently, the CDC rules are extended through June 30th, 2021. In early May, a federal court judge struck down the CDC Eviction Moratorium, and there was a blast by, I think, CAR, or maybe it was NAR, that it was in part the associations of realtors from a couple other states that were behind that, that lawsuit. However, the judgment is now on appeal, which means that that judge's decision is stayed pending the appeal. So the CDC eviction moratorium is still in place, and we'll find out what happens once that appeal is completed. But the CDC moratorium hasn't really affected what I do. In my office, we do perform evictions. We have succeeded in being able to evict several tenants, and since about October 2020, we were able to start moving these cases through the courts. And so the CDC rules haven't really come into play. I'll explain to you how they would come into play if they were. But also on the federal side, there's federal stimulus money that's being used to fund a renter's aid program. $1.7 billion was given to the state of California by the federal government. And the proposal at this time is to use those funds to help income qualified tenants or their landlords in exchange for an agreement where the landlord would forgive some of the past due rent. Access to those funds can be obtained through a website called housingiskey.com. Housing is key, KEY.com. The program that you'll find on that website is, there are two. One is a program where the landlord and the tenant cooperate, and the tenant applies and shows that if they can show that they are qualified, they can obtain 80% of their past due rent from these funds. In exchange, in order for the landlord to get those funds, the landlord has to write off 20% of that past due balance. So if the landlord agrees, then the landlord gets the 80%, and they can reapply as time goes on if the tenant is still unable to pay the full rent. The other program is where the tenant may apply without the landlord's participation for 25% of their past due rent. And even if the landlord chooses not to cooperate, the landlord does not have to write off any of the balance, but may still receive 25% toward the tenant's past due balance. So federal funds for non-payment of rent are also available through the City of San Diego, through its agency, the San Diego Housing Commission. And the City of San Diego has received $42 million in federal funds to put toward its own relief program. That's information that I have found out in the public record. I personally have not had any of my clients actually receive any of the federal funds or the city's funds or any funds from the state. It was also in a news article that the state of California will be proposing to use state funds for the for some sort of rental assistance program. But as I said, you know, to my knowledge, those funds have not been issued yet, and I do have several clients who are waiting for them. Okay, so then with regard to residential eviction, the COVID law's impact on the direction of residential evictions will be affecting evictions through 2026. Those laws have temporarily changed a lot of the laws that come into play with evictions and potentially have permanently changed them. The most immediate and biggest impact is during the time period of tenancies from March 1st, 2020 through June 30th, 2021, and then potentially as extended after that. We suspect it'll probably be extended through December 31st, 2021. In addition, portions of the new law will continue to affect all of the evictions through 2026, including longer notice periods. Instead of a 3-day notice to pay rent or quit, or a 3-day notice to terminate the tenancy based on the tenant's at-fault action, it's now a 15-day notice. And as you know, because the CAR forms have all been updated to reflect that. There are also stricter or narrower definitions of just cause. And in order to fully understand the new COVID Tenant Protection Act, as well as the new San Diego County law, I keep a series of documents nearby, actual copies of the statutes. I have the 2020 COVID Protection Act, which is Civil Code 1179 et sec. And this also includes the amended Code of Civil Procedure, section 1161. 1161 is the statute that we always refer to when we're considering there are 4 bases for a 3-day notice to pay or quit, or a 3-day notice to evict someone because of nuisance or waste, or a 3-day notice to evict because someone is subleasing illegally. That all comes from 1161, which was amended to incorporate 1179. 1179 Code of Civil Procedure is the new COVID Tenant Protection Act of 2020, and then 1179 incorporates the definitions that were provided by AB 1482. That's the 2019 Tenant Protection Act. So it used the AB 1482 statutes to bring in the definitions for just cause evictions that now become the reasons that we evict, the only reasons that we were permitted to evict tenants throughout the state. As I said, every eviction now has to have just cause pursuant to the definitions provided in the AB 1482, the 2019 COVID, the 2019 Tenant Protection Act, not the COVID Act, which was the 2020 Act. And then the 2020 Act made some adjustments to those definitions to actually make them even narrower. Now the San Diego County ordinance has changed that significantly and gotten us down to basically one just cause that we can use. So I keep a copy of the new statutes. I also keep a copy of the AB 1482. It's this Civil Code 1946.2, because this lists all the reasons that we're using if we are able to evict someone. And now I also have the San Diego County one printed out on my desk and highlighted. All right, so the AB 3088, which was the COVID Tenant Protection Act, created 3 categories for evictions that we may be able to move forward with. The first category is that the tenant was guilty of unlawful detainer prior to COVID, prior to March 1st, 2020, a notice was issued and expired, and now the landlord could move forward on that eviction. These are very rare because anybody who hasn't moved forward on one of those evictions probably won't be able to. In the second bullet point is specifically if a tenant is served with a new notice demanding payment of COVID-19 rental debt, they failed to comply with the requirements of the 2020 Act. Specifically, that means that the tenant failed to submit the declaration that gets served with the notices to the landlord or to the court. The declaration is the California COVID declaration, where the tenant signs at the bottom that they have a COVID-related hardship. So if they fail to respond to provide that to the landlord within 15 days, they may still provide it to the court. And if the court sees this declaration anywhere in the court's file, the court must schedule a COVID hardship hearing. The hardship hearing, if the tenant shows up and says that they have a COVID-related hardship, and if they can provide some sort of explanation why they were unable to deliver the declaration to the landlord in time, the entire case can be dismissed. The good part of that is that it doesn't designate the tenant as a prevailing party. So even though the case gets dismissed, the landlord is not liable for the tenant's court costs or attorney's fees. It just gets dismissed and the landlord has to start all over. We've attended many of these COVID hardship hearings, and at first it was a foregone conclusion that if the tenant shows up, case is going to be dismissed. But lately, we've had the experience where we've had one and we've seen others where the case was allowed to move forward based on COVID related rent because the tenant just didn't have a good cause as to why they didn't submit the declaration in time. Now, the third bullet point is really where most of our evictions that we have been able to move forward are living. The third bullet point is that the unlawful detainer arises because of termination of a tenancy based on at fault just cause or no fault just cause as defined in 1946.2 B1 or 2 with the adjustments that were made by the 2020 COVID Act. So I'll explain what that means. Under the 2019 Tenant Protection Act, there was this list of at-fault just cause definitions. These are things that a tenant could do that would cause their eviction. Default in payment of rent, breach of material terms of the lease, nuisance and waste, expiration of a fixed term lease, criminal activity, tenant refusal to allow entry, assigning subleasing, using the premises for an unlawful purpose, an employee who was living there based on their employment and refuses to vacate after they're terminated, or the tenant says that they're going to move out, provides a written notice that they're going to move out, and then fails to move out. So under the 2020 COVID law, we crossed out a few of these. We cannot evict for default in payment of rent. Those are the orange bullet points that are crossed out. We cannot evict for breach of a material term of the lease, and we cannot evict for assigning or subleasing. These are all considered COVID-related, hardship-related types of evictions. Now, under the San Diego County Board of Supervisors ordinance, we have to cross out a few more, and we add one. So the interesting thing is the ordinance provides one reason why you may be able to evict someone. That's because the tenant is a hazard to the health or safety of other tenants or occupants of the same property. If the tenant is causing a nuisance or waste that threatens the health or safety of other tenants or occupants of the same property, you could still use nuisance or waste as a reason. If they are committing criminal activity, and that is a threat to the health or safety of other tenants or occupants, you could use criminal activity as a reason for an eviction. If the tenant is refusing to allow entry, which is causing, again, a hazard, then that could be used. And if their use of the premises is an unlawful purpose, think about maybe a meth lab or something like that, that's a pretty serious hazard. And, you could still evict someone for that reason. But the notice, and I'll talk about notices as well, but there's new language that's required if you're going to issue a notice to a tenant for one of those reasons. I'll go over that in a minute. Now we have no fault just cause evictions. So these are reasons that we were able to proceed with evictions when the tenant is not at fault, but because the landlord would maybe intend to occupy the property, or they're going to have their spouse, domestic partner, children, grandchildren, parents, or grandparents occupy the property, or they were going to withdraw the property from the rental market. But the COVID 2020 law added a few elements to this. It wasn't just withdrawing the property from the rental market. The property had to be in escrow for sale to a bona fide purchaser at fair market value with the intent, the buyer has the intent to occupy the residence, and the seller is not a corporation. So if you can check all those boxes, we have been able to proceed with evictions based on bullet point 1 and bullet point 2. Those have formed the basis for the majority of the evictions that we have successfully had in the last six months. An order by a government agency relating to habitability, an order by a government agency to vacate the premises, a local ordinance that necessitates vacating the premises, or a substantial remodel as defined in the new 2020 COVID Act. So under the 2019 Act, a substantial remodel that requires permits could go forward regardless of whether habitability is an issue. But under the 2020 Act, they redefined a substantial remodel as being necessary to bring the property up to code to avoid a health and safety hazard, to bring it up to habitable standards. But now what we have is under the San Diego County ordinance, no fault just cause doesn't really exist, except if there is an order by a government agency or a local ordinance that somehow comes into context of something that the tenant is doing that's a hazard to health or safety. So let's say that the tenant does something, causes an explosion or something, and now the property is being condemned and the tenant has to vacate. That's one scenario where we might be able to use for an eviction. All right, so after June 3rd, let me make sure I'm on the right page here. You know what, let me go back. Well, I'll just talk about this for a minute. There is some relief for landlords. I've touched on this. There is the federal funds available through housingiskey.com or through the city of San Diego. There is mortgage forbearance available to landlords who can't pay their mortgages. At this point, we would not expect to see a lot of foreclosures moving forward because it seems fairly easy for people to access forbearance programs through almost any lender, except for possibly your hard money lenders for residential properties. And there is quite a broad opportunity for collecting rent after the fact. So collecting rent from a tenant is not a great place to be, but at least you might be able to still get a judgment from the tenant because technically the tenants still owe rent. Now, notices to tenants. I am saying no notices to tenants because after June 3rd, no notices will be permitted under the San Diego County ordinance unless you have one of the reasons that's authorized by the ordinance. If you have a reason that's authorized by the ordinance, you know, your tenant is you found that the tenant is a threat, a hazard to the health and safety of other tenants, and you have evidence to prove that, then you can issue the notice, but you have to put in your notice new language that is underlined and in bold in the ordinance stating, quote unquote, the emergency eviction moratorium is currently in effect. Other than for failure to pay rent or an imminent health or safety threat, evictions are restricted during the local emergency declared by the County of San Diego. Tenants who are being evicted for failure to pay rent may have additional protections under California law. You may contact Legal Aid Society of San Diego or the Legal Referral and Information Service of the San Diego County Bar Association, and contact information is provided. There's something wrong with the language here. I'm not sure why it says this, but it says other than for failure to pay rent or an imminent health or safety threat. And I'm looking at the statute with the signature page on the end. So I don't know why it says other than for failure to pay rent, because as I just told you, we can't evict for failure to pay rent. So the CAR notices that are in your zip forms apply statewide, and they are no longer compliant with San Diego County unless they're just not compliant. I wouldn't use the CAR forms if someone were to choose to go forward with a notice based on a reason that seems to be authorized by the ordinance. I would have a separate document drafted. Also, there's an advisory that SDAR is working on. I've assisted them a little bit with drafting that so that realtors can use them, not for notices to tenants, but for transactions where you want to make sure that a buyer understands what they're getting into right now. In the absence of the San Diego County ordinance, the notices that we have been using have increased substantially. What used to be just a 3-day notice to pay rent or quit is now a 15-day notice, a notice from the state of California that describes the tenant's rights, and a declaration that's attached for the tenant to sign. And then we've also been cautious about making sure that we issue the AB 1482 notice of exempt or not exempt property, which arguably should have been done a long time ago or incorporated into the lease, but we're staying on the safe side of that and just trying to make sure that all appropriate notices get served. So sometimes we're issuing 5 notices to each tenant. And then with our 30 or 60-day notices for no fault just cause reasons, these may still require relocation assistance unless the landlord has timely complied with the notice of exemption from AB 1482. So that's a little tricky one that we get caught on sometimes when the landlord hasn't not timely issued the notice. And there are other notices that are sometimes required. I'm not going to go into what the notice from the state of California says about the tenant's right to pay 25% of the rent, but that is still in effect, that if the tenant pays 25% of the rent, past due rent, on or before June 30th, 2021, that they are protected from eviction for up to 1 more year. If, as of July 1, they start paying their full rent, and as I said before, this may get moved to December. And despite the San Diego County ordinance, that is still in effect, that if the tenant pays their 25%, they could be protected. From a tenant's perspective, you would want to still comply with that because we don't really know when the San Diego County ordinance will be lifted. Technically, the San Diego County ordinance is effective until the state of California lifts all stay-at-home and work-at-home orders, and 60 days thereafter. So it's in effect for 60 days after the state of California lifts all stay-at-home and work-at-home orders. Okay. There are some new court procedures and forms. You guys don't need to worry about these, but just to be aware that in response to all of these new laws, the court has updated the standard complaint form, the writ of possession form, and has some new cover sheets that need to be submitted as well, depending on the circumstances of each case. So tenant hardship declarations. There are 2 hardship declarations that are in play. There's the California Declaration and the CDC Declaration. They have different effects on cases, and so I just thought you might want to know. With the California Declaration, most tenants would have no problem signing this and claiming a hardship. Hardship could be defined as loss of income caused by COVID, increased out-of-pocket expenses relating to performing essential work during COVID, increased expenses directly related to the health impacts of COVID, childcare, elderly and disabled family members, responsibilities directly relating to COVID, increased costs for family-related responsibilities, or other circumstances directly related to COVID that reduced income or increased expenses. So it's very easy to qualify under that. And if the tenant provides the declaration either to the landlord or to the court, then the court must schedule the COVID hardship hearing and the case may be dismissed entirely and the landlord would have to start over. So that is why we are really not moving forward with any of the non-payment of rent or subleasing type of evictions at all, because it's just a waste of money. It's too likely that that case would get dismissed. And then the Center for Disease Control, the CDC Declaration, has a very different effect on a case. It does not necessitate any kind of court hearing prior to trial, but the issues in the CDC Declaration create issues of fact that the tenant may attempt to prove at trial. And if the tenant can prove that they qualify under the CDC moratorium, then the case may be dismissed at trial and the tenant may be the prevailing party. The CDC states that its regulations do not apply if state law is more protective than the CDC rule. It's very unclear, in my opinion, which one is more protective because they are apples and oranges. They have very different effects on the case, and the information in the CDC declaration is very different from the information that the tenant declares in the California declaration. For the CDC declaration, the tenant has to declare that they've used best efforts to obtain available government assistance and make partial payments, that they have income less than $99,000 for a single person or $198,000 for a couple, that they've had substantial loss of household income, and that they would likely become homeless. They have to qualify for all of these things together in order to qualify under the CDC. And again, the CDC does not relieve the tenant from responsibility for payment of rent. A couple, I'm about to wrap up, but a couple other details that you might find interesting. Most of the eviction trials that have gone forward since October 2020 have been virtual trials, which are challenging because people are on computers instead of in front of you. So the whole procedure of putting on a trial and presenting evidence is frustrating, to say the least, for everyone involved. People have masks on, they're on their phones, there's feedback, there's translators. It's hard to see documents if the people don't have them in front of them. And it's just very difficult, but we've managed. And most of the courtrooms use Microsoft Teams for those virtual trials in San Diego County. Jury trials are moving forward. I was very fortunate to be the attorney representing a plaintiff in the 4th civil jury trial in San Diego County since COVID started. We had a jury trial at the beginning of April, April 12th, 13th. No, I'm sorry, it was the 13th, 14th, and 15th. And so, they brought in 40 jurors into the room. Everybody was socially distanced. There's plexiglass everywhere. Everybody was wearing a mask. And we chose our jury, and we had a 2-day eviction jury trial with Judge Enright. It went very smoothly, and it was nice to see that it could happen in today's environment. And the observation is that that it is possible. It was a very popular tactic by tenants to request a jury trial before we knew that juries were going to start going forward for a while. And even we were very surprised in April that we got called in because we had no idea they were starting to do them. So up until that point, we had no idea if jury trials were going to go forward this year or maybe even wait until next year. So tenants were taking the chance of requesting the jury trial just to get the delay because then the court would not schedule their virtual trial. Enforcing judgments for possession is also a challenge. For example, we got a judgment for possession against a tenant who stipulated to their move out. They agreed to move out January 4th. They signed an agreement. We did not have a trial. They said they would move. They didn't move. And pursuant to the stipulation, we are allowed to enter judgment. The judgment took a couple weeks for the court to process, and then it went to the sheriff, and the sheriff delivered a notice to vacate posted on the door of the property on February 4th. We were very relieved by that. The tenants left voluntarily, and we forgot to cancel the sheriff's lockout. But this was an interesting lesson to us, because then on April 22nd, we finally got a call from the sheriff's department saying that they were ready to do the lockout for this particular property. It took over a month and a half from the time when the sheriff posted a notice to vacate to the time when they actually were ready to pursue the lockout. And I think that that time frame is going to get worse with now the San Diego County ordinance. But for the most part, the court is up to date, and the court is moving the paperwork through in due course, and the trials are happening in due course, and we're not waiting very long for the court. The courts are not terribly backed up at the moment, and relative to where they were prior to COVID. And we've already talked about small claims court, the opportunity to pursue judgments for unpaid COVID-related rental debt, and the danger of retaliatory claims by tenants. And so I'm not going to go back over that. But if you have any questions about those issues, I think we may have some time for some questions. So, you know, this is how I felt at the beginning of 2020, when I thought that the AB 1482 was going to be the most difficult part of my job. And I was, you know, gearing up to handle those issues all year long. And then boy, was I wrong. When 2020, when COVID hit, it just all kind of got a little bit crazy. So, but we're managing. All right. So if anyone would like to ask questions, or maybe there are some other announcements, I don't know, let me know. I'll look at the chat. But that's all as far as the webinar for me. Let's see. Oh, there's a lot in the chat.
There's a bunch of great questions in the Q&A as well, Shanna.
Okay, yeah, sorry about the audio. I don't know. I do webinars a lot, so I thought my audio was pretty good. I'll look at these Q&A. I apologize though if I've been having issues with the audio. If it's a month-to-month lease, can a 60-day notice be given without any cause? The answer is no. Statewide, you have to have a tenant at fault just cause, or a tenant no fault just cause. And those definitions are very similar to they adopted those definitions from the 2019 Tenant Protection Act, but with certain adjustments as I went through in a couple of those other slides. How do you know if property is exempt or not? That's a good question. That's under the AB 1482 law. And I have a bit of an explanation on that one. I have a handy little table that I made way back at the beginning of 2020 that helps to make that analysis, but it's not simple, and it's based on the aspects of the property and the ownership. So we kind of take that, each one of those analyses as they come. Oh, I don't have my table here for some reason. But that's something that you could contact me or contact my office if you want to know whether a property is exempt or not exempt. The failure to claim the exemption for a property that would otherwise be exempt, if the exemption is not claimed, then the property is not exempt. So there was a notice that was supposed to be served by August 1st of last year. And if the notice was not served, then the landlord must incorporate the language of exemption into the lease. So the CAR form has that in the lease, and I believe you check a box as to whether the property is exempt or not exempt. The analysis of that is something to be done separately. So if we do a rent increase prior to June 3rd, then we can still use the 6% for non-exempt and 10% for exempt properties. Yes, that's true, but my caution was to not do any rent increase because of the AB 80, which is, you know, that started this course of preventing landlords from giving the tenants any late fees or penalties. and also strengthen the language with regard to retaliatory evictions, that you do not want to do a rent increase if there's any chance that the tenant might see it as retaliatory. So it's kind of at your own risk if you're going to try to increase the rent. Make sure you stick within the guidelines, and hopefully you don't get any feedback from the tenant about that. Will a recording be shared? I believe so. I think it's going to go on the SDAR YouTube page. So just a caution that the provisions of the county apply. This is a good point. So the San Diego County ordinance applies to the entire county, even the incorporated areas of the county. So, you know, we've got unincorporated areas of the county, and then we've got incorporated cities like City of San Diego, City of El Cajon, City of La Mesa. This County Board of Supervisors ordinance applies to the entire county, not just the unincorporated areas. It applies to the City of San Diego and all of the other cities I mentioned, and all of the cities that I didn't mention. Are you able to evict squatters? There's a special rule about squatters, and I don't know. In fact, I haven't had the opportunity to contemplate that. I would say probably not, just because of the general policy against evictions, you know, against displacing people. The policy behind all of this is the desire to not displace people during COVID, especially people of low income or who are having trouble with their income. The justification by the county for their ordinance is very well thought out and very well explained in the ordinance. They identify reasons such as COVID, but also fear of evictions, where many tenants might self-evict if they are afraid of having an eviction on their record or having legal claims brought against them. They have some very thorough statistics about the severe effect that this has, a much greater effect on certain racial minorities and socioeconomic injustices, the way that COVID has affected certain communities, particularly of certain minorities and of certain levels of economics. And then they cite the already very severe housing affordability crisis that San Diego most certainly has and continues to have. And we can all feel the effects as realtors of how that has increased during COVID. You know, the housing market is nuts. I don't envy you guys having to sell properties in this market. Moving on, can a homeowner give notice before June 3rd if they are putting their property on the market for sale now? You have to be in escrow for sale to a bona fide purchaser at fair market value, and your buyer has to intend to live in the property. The notice that you would probably need to give for that would be a 30 or 60-day notice, depending on how long the tenants have been there. And it's a little unclear to me when this ordinance goes into effect whether it would invalidate any pending notices that have already been served. It certainly invalidates any notices that are served after June 3rd. My response to that question has been, you know, go ahead and serve your notices. It's not illegal yet. Whether or not you can enforce them remains to be seen, and probably not. You probably won't be able to enforce them until much later when the ordinance is no longer in effect. If a tenant is paying 25% rent but has not sent in their hardship declaration, can we start the eviction? They've been served with notice and are now past the 15-day period. If they're paying the 25% rent, they will be protected from eviction even if they do not serve the declaration. That's my understanding. If they go in and well, first of all, the rule states that if they pay 25%, they're protected from eviction. But second of all, if you start the eviction and they give the declaration after the fact, you could still get your case dismissed. So it could be a waste of time and money. But you could try it and see what happens. Like you said, we were surprised because we had some tenants who actually didn't succeed in delivering the declaration late. You know, we thought it was a foregone conclusion that even if they were late with the declaration, they would still win the hardship hearing. So we were surprised when these hearings started to go in the landlord's favor. So, you know, it's really up to the landlord what kind of risk they're willing to take. But as of June 3rd, all of this changes because I'm not even sure after June 3rd if I'm allowed to attend a hearing on one of my pending cases. And we've got an eviction. We went to jury trial. We have a pending judgment for eviction that the sheriff has not executed yet. And I think after June 3rd, if they haven't executed it by then, the sheriff's going to stop enforcing writs of possession. Let's see. What about short-term rentals? A 3-month rental, like a vacation rental. Can the person be forced to leave? A 3-month rental is not a short-term rental. Anything over 28 days, it forms a tenancy. That's the way that I analyze those rules. If it's a lodger, they have to be there for 28 days or less. So, but vacation rentals, if you can show that they're a lodger, I believe that the sheriff will help you to move forward with removing them. There's also a separate procedure that you can go through to get a quick move out order. It's kind of like a restraining order, and I haven't done too many of those, so I'm a little bit uncertain about how that's working right now. But if the person is a lodger, then they are not a tenant. And so all of this hubbub about protecting tenants doesn't really apply to them. So what forms are available for notice to vacate? I have my forms. Like I said, the CAR form, if you're going to use it after June 3rd, doesn't have the additional language. So I would recommend talking to a real estate attorney and allowing a real estate attorney to advise the landlord about how to proceed. I have a client who has a tenant who has not paid rent before COVID and will not get out. He is also causing damage to the unit as well. What can we do? You know, unless the notice was served prior to COVID and unlawful detainer was established before COVID started, you're in the same boat as everybody else as far as proceeding with an eviction. And so, you know, on a case-by-case basis, we would have to determine whether there's any just cause for the eviction. And then after June 3rd, unless he's a hazard to health and safety of other people living at the property, you'll be out of luck until that ordinance is removed. Oh, by the way, I don't think I mentioned there is a legal challenge to the County Board of Supervisors ordinance, and that legal challenge is spearheaded by the Southern California Rental Housing Association, SDAR. I am informed that SDAR is supporting the legal challenge, and they are looking for potential plaintiffs who will fall into the category of someone who has a just cause basis for eviction right now. I know I have a few cases that are going to be stopped when June 3rd, when this takes effect. So hopefully that potentially, I assume they are requesting an injunction to stay the ordinance from going into effect, but I am not holding out a lot of hope because I don't know that that would be a successful effort. In an effort to protect against delinquency, for new potential renters, can you collect several months rent up front? If so, how many months can a new renter prepay? That's a good question. Really, it's up to the landlord and tenant to decide how many months the tenant wants to prepay. I've seen many tenants prepay for a full year, and I haven't seen anything longer than that, but it's very common for a tenant to pay upfront for a full year. I have a client who sold her home, closed escrow yesterday. Her daughter is being difficult about moving out. She does not pay rent or perform services in lieu of rent. The seller has a seller in possession addendum, SIP, until June 4th. There is a 10K holdback, which is forfeited fully if the property is not vacant by June 21st. What would be the best course of action? Hopefully the 10K holdback is a good enough incentive to influence them to move out. Otherwise, there's not much you can do except, you know, potentially legal action after the fact. You know, June 4th, let's assume that the ordinance is in effect, and so you wouldn't be able to evict that person unless they're imminent health and safety hazard. Is there a section in state law allowing local jurisdictions to pass greater restrictions on renting or rent? I think this is my friend Charles. There's a section in state law allowing local jurisdictions to pass greater restrictions on renting or rent. I don't know that that's in state law, but local jurisdictions do have the right to pass stronger restrictions than the state. And if under most laws, it's actually set forth in the state law that the local jurisdiction may have a stronger rule. And under most of those, if the local jurisdiction is stronger than the state, then the local jurisdiction will prevail, will apply. Can a tenant be forced to leave on a sublease? Subleasing is protected by the 2020 COVID Tenant Protection Act. Similar to non-payment of rent, the logic is that if someone is subleasing, they are splitting the rent, so they probably have lower income. And if you evict two people who are subleasing, they are going to go and sublease with another group, and that's going to increase the volume of the population. You know, people living together would tend to spread the pandemic more quickly, and so they are trying to prevent people from doubling up like that. It's 1:08. I'm not sure if you guys want me to keep going. There's a lot of questions, and I'm happy to answer, but I also wonder if you guys want to keep going. Anybody? Okay, well,
Shanna, yes, if you don't mind, however long you're able to stay with us, and I know there are a lot of questions both in the chat and in the Q&A, so whatever time you have available, we are absolutely grateful for any questions you can get to.
Sure, no problem. I have another meeting at 1:30, so I'll go to 1:25 and see how many of these I can get to. Happy to do it. Okay, so if the lease expires, you cannot inform the tenants that you do not plan to extend the lease and have them move out. If the lease expires, you can't inform the tenants that you don't plan to extend the lease. Oh, okay, good question. So used to be, except for in the city of San Diego, as far as I know, you know, for my frame of reference, it used to be that anywhere in the county other than the city of San Diego, if a tenant had a lease that was expiring, at the end of the lease, you could give the tenant notice that they are not allowed to hold over and require them to move. And you could evict them based on your notice to the tenant that they are not to hold over. Some leases already state that. Under the 2020 COVID Protection Act and under the San Diego Municipal Code, so San Diego Municipal Code said that once a tenant is there for 2 years or more, you have to offer them a new lease and they have to reject it. You have to give them written notice that you want to offer them a new lease, and then the tenant rejects it, and then you could move forward with eviction based on the termination of a fixed term lease. Statewide, under the 2020 COVID Protection Act, they added a very similar provision to the just cause evictions. So under 2020 COVID Act, In order to evict based on the termination of a fixed term lease for any tenant, it doesn't have that 2-year thing that San Diego had. Any tenant whose fixed term lease is coming to an end would have to be offered a new lease for similar terms, and they would have to reject that offer before the landlord is able to move forward on the eviction. So it makes it a little more complicated to terminate based on a fixed term lease. And I get that question a lot. And I understand that it makes a lot of sense that, you know, you rent to someone for a year, and when that year is up, you should have the right to evict them. But under the 2020 COVID Protection Act, they took that away, at least temporarily through 2025. And all of these things could be amended at any point in time. Does local law preempt state law? Yes, sometimes. If the local law is more restrictive than the state law, and if the state law allows for it, the local law may preempt the state law. What would the process be to sell property, old hovels that can't be remodeled or renovated, but need to be torn down, that are currently rented out? Without cooking appliances, furnaces, etc. Buyers cannot move in due to habitability. You would also have trouble evicting people from those hovels due to lack of habitability. Really, any lack of habitability will make it an extra special challenge to evict people. And so what we were using under many circumstances, I think your point is well taken, that a buyer is not going to move in necessarily, but we did just have an eviction where the buyer intended to move into one of the structures, which was an unpermitted mobile home unit. There were other unpermitted structures on the property. In fact, there were 4 structures. The buyer's intention was to live in the unpermitted mobile home unit and build a home that they would live in. So we were able to proceed with the eviction similar to your scenario here. But I think that that would be an especially difficult scenario under any circumstances, but even more so today. If a property is exempt and no COVID hardship, and the owners want to sell the property, can they give the tenants notice to move prior to June 3rd as a just cause? Now, prior to June 3rd, there's no restriction against giving appropriate notices to tenants. The problem is that if I gave a 15-day notice today, it's not going to expire in time to enforce it. So, you know, what you might hope to do is scare the tenant away who doesn't know what their rights are and who isn't watching the news. But you'll find that many tenants will find legal aid. Many tenants will find the information that they are protected. And then if you go and file your lawsuit, you end up having a tremendous amount of liability for proceeding with an eviction under the new county ordinance once it goes into effect. Can we increase the rent if they are current on the rent and the expenses went up? Yes, within the rent caps. So under the county ordinance, it's just 1.036%, which isn't very much. But you know, it depends on how your lease is written as well, because some leases say that the tenant is responsible for paying the utilities separately. So, you know, automatically, if they're paying utilities and utilities go up, they have to pay that increase. But if it's incorporated into the rent and it's not itemized, then you'll have more trouble. If it is itemized, I don't know. I mean, maybe you can try it and see if the tenant understands. And you can also enter into a new agreement for payments with a tenant if they'll agree to the increase. You just put that in writing and everybody signs off. You can alter any part of a lease if it's a mutual contractual change. let's see, what is the county rent increase guiding percent? SC Consumer Index for April 2021 is blank. Yeah, I think it was Ryan who mentioned to me that they don't publish the local CPI in April. All I could find was the statewide, which was from the Board of Equalization. I couldn't find the specific local CPI, nor does the County Board of Supervisors indicate that what CPI is supposed to be used. It was very ambiguous with regard to what the CPI measurement would be. Sorry, I can't be more specific about that. What about a rent back on a property sale? What if you do it and the seller, now a tenant, does not leave? I fielded that question for a realtor just the other day, and they laughed because what you could do is going to discourage the reason that you're offering the rent back. I know that offering the seller a rent back is a nice incentive when you're trying to compete with other buyers to get that seller to accept your offer. Under normal circumstances in a regular market, I would say the best way to keep that seller from holding over on that seller in possession addendum is to have a nice healthy per diem that if they hold over, they owe some X number of dollars a day. And I've seen them where it was $2,000 a day. And that is enforceable. So that's a great incentive. But the comment from the realtor that I spoke to the other day was that that's going to be a disincentive, and it just contradicts the whole reason that you're offering the incentive in the first place. Anyway, the way to prevent it is to have a contractual agreement where they owe a lot of money if they hold over, and that's usually enough. And you can enforce that. So if the buyer has to go rent someplace else, make sure that that per diem covers whatever cost they would have if they have to go rent someplace else. Is the stay-at-home and work-at-home order planning on being lifted June 15th when the tier system goes away? I hope so. I think June 15th was the date that was announced as a reopening, but I don't know if that's actually going to happen because these things always seem to get continued. And I get my news from the same place you guys get it, the newspaper and online. So I think that's anybody's guess. But if it does, then if June 15th is the date that all the stay-at-home and work-at-home orders go away, then we still have 60 days under the San Diego Board of Supervisors ordinance. If you rent to a person for a month and have a new person coming to rent the next month, can you force the month-long tenant to leave? Can you force them? Not without the appropriate eviction procedures. Now, if they're there for a month, are we talking short-term renter? If we're talking 28 days or less, then you may have some other tools available to remove the person, to force them out using the sheriff and using a order for possession based on them being a lodger. But if they're a tenant, meaning they're over 28 days, you cannot resort to self-help to force someone to leave. That would be a wrongful eviction. So you're strongly cautioned against doing anything that might qualify as force. Force, the term could be interpreted as, obtaining a writ of possession and having the sheriff go out there and enforce a lockout procedure. So in that sense, yes, you can force them to leave, but it could take an extended period of time to make that happen. Okay, so 5 more minutes. Do you guys have any announcements that you want to make before we finish up? All right, I'll just keep going until you guys interrupt. Have tenants that sublease, the tenants left and the sublets, not any lease, have chosen to stay. Oh, okay. So the subtenants have chosen to stay when the main tenant has moved. can you remove them? They're not paying rent and we have mold to remediate in the property. It's a tough one. I mean, they're, even if they are just there pursuant to a sublease, they are still tenants nonetheless. And so you still have to have one of the just causes that we went through in my slide in order to force them to move, in order to quote unquote remove them. So non-payment of rent is not a basis. Illegal subleasing is not a basis that we can use. And even habitability of the premises after June 3rd, we can't use. Prior to June 3rd, so if you have to do substantial remodeling in order to bring the premises up to code, in order to remove that mold, then you might have been able to use that as a basis for an eviction. But that would have been a 30 or a 60-day notice, and you're not going to be able to enforce it prior to June 3rd. So if a lease term is up, so next question, if a lease term is up, the home is exempt from 1947 Civil Code, can you serve 30 or 60-day notice to sell after the RCJC and NTT CTRA are served? You know, I'm not sure what your acronyms are representing. I have some idea, but as of now, the answer is no. I mean, you can serve a 30 or a 60-day notice prior to June 3rd, but after June 3rd, you cannot. And even if you did serve them prior to June 3rd, you won't be able to enforce them. Okay. Sorry. The amount that one can increase the rental rate. So there are 3 measures for increasing the rental rate, but as of June 3rd, everything gets reduced to 1.036%, which is the CPI that I found. I'm using that number because that seems to be the California Consumer Price Index increase from 2019 to 2020, which is what the Board of Equalization has identified for 2021 as the appropriate inflation factor. Kind of. I mean, this isn't really my specialty as far as calculating this stuff, but when AB 1482 came out and the question arose, you know, what is CPI and what are we allowed to use? What numbers do we use to increase the rent? It's really, if you end up in court having to defend your rent increase, you want to have something to support it, because they were not specific and they're still not specific. So no matter what you do, you just want to make sure that you have support for whatever you choose to, whatever increase you choose to make. So the sublease question, this is a reference to one of our earlier questions. It's not about people living together. This person rents an apartment and they're away for a while, so they subleased it. What if the person won't move when you return? It would in part depend on what the sublease says, because arguably, if it's a sublease, if it's a proper sublease, the sublessor might be allowed to live there as well. So it really depends on what the terms of the sublease were. But otherwise, if you're not allowed to just move back in with them, then it's an eviction situation, and you know you're going to have the same problems that we've been going over this whole time. Is email okay for written notice? It depends on what kind of notice. So let's see, a tenant corresponds via email with the landlord. In case of tenant giving notice or landlord serving any notices of or rent increase, etc. Or must written notice be a letter in the mail? It depends on the terms of the lease, because for anything other than notices to terminate the tenancy, increases in rent may be pursuant to whatever the lease says. So if the tenant has agreed to service by email or even text message, then it's possible to send a notice of rent increase in that way. But if you go per code, if you go to the statutes for rent increases, it's always going to be first class mail, or some statutes for other things, not for rent increases. But there's also some statutes that direct you for certified mail. And then for notices to terminate the tenancy, you always have to make a diligent effort to serve the tenant personally, and then you could post and mail them. And that posting and mailing is a taping it to the door and then mailing it by first class mail. I have to run. I'm very happy for all these questions and happy to assist you in any way that I can. I'm sorry to run out of time, but maybe we can do this again sometime.
Jana, thank you so very much. Yes, as you can see, a lot of engagement in the chat and Q&A, and thank you so much for sticking around for as long as you did.